It's 9:47 a.m. on a Tuesday. Marcus is working from his home office. Sunlight coming through the window. Coffee getting cold on his desk. He's been clicking through design files for about an hour when he notices something. A small icon in his taskbar. Something he doesn't remember installing. He clicks on it. A window opens. And what he sees stops him cold. The software is tracking everything. Every keystroke. Every website. Every moment he steps away from his desk. But here's what Marcus didn't know. This was completely legal. Marcus had been working for the company for 3 years. A fully remote designer. He liked the freedom. He liked working from home. Then, one Friday afternoon, an email arrived. Subject line, new productivity monitoring policy. The company was implementing mandatory software on all employee devices. The reason, they said, was to ensure accountability and protect company data. Marcus read through the policy. It mentioned the software. It said he had to install it, but it didn't really explain what it did. So Marcus installed it. He didn't think much about it until late that Tuesday morning when he decided to investigate. He opened the application settings, and he started clicking through the logs. The software was recording every application he opened, every website he visited, every single keystroke. But that wasn't the part that made his stomach drop. The software was taking screenshots, automatic screenshots every 5 minutes, pictures of his entire screen. And he realized something immediately. Those screenshots captured everything. His password boxes, his personal email, the mental health forum he'd been visiting, his private Slack messages, everything. Marcus picked up the phone. He called HR. He said this felt like a violation of privacy. He said it felt like the company was reading his mail. The HR representative listened. Then she told him, this is standard. This is legal. And if he didn't like it, he was welcome to find another job. She said it with no hostility. Just as a fact. Like she was explaining company policy about the bathroom. Marcus got off the phone. He looked at his bank account. He had maybe 6 weeks of savings. He looked at the job market. He looked at the software, still logging everything he did. And he realized he had no good options. Here's what you need to understand about privacy in the American workplace. In most situations in your life, you have a right to privacy. The government can't search your home without a warrant. Your phone calls are protected by law. Your emails are protected. Your doctor has to keep your health information confidential. But the moment you clock in at work, those protections weaken dramatically. The legal principle is called the reasonable expectation of privacy doctrine. It works like this. If you have a reasonable expectation of privacy in a particular space or situation, the law protects it. But courts in America have consistently ruled that employees have almost no reasonable expectation of privacy at work, especially on company equipment, especially on company property. Why? Because the employer owns it. They own the computer. They own the network. They own the desk. They own the building. And so they have a right to see what's happening on their property. The employer's ownership right trumps the employee's privacy right. That's the basic legal principle. That framework comes from a 1986 law called the Electronic Communications Privacy Act. The ECPA actually says employers can't intercept employee communications. That sounds protective, but there's a massive exception. Employers can intercept anything that's related to the ordinary course of business. That exception has been interpreted so broadly, it covers almost everything. Want to monitor employee email? It's related to the ordinary course of business. Want to track keyboard input? Related to business. Want screenshots of their screen? Related to business. Want GPS data from their work phone? Related to business. The exception basically swallows the rule. The only real requirement the law imposes is notice. The employer has to tell you monitoring is happening. And almost every company does, usually buried in an employee handbook. That's it. That notice counts as consent in the eyes of the law. You're informed. Therefore, you've agreed to be monitored. If you don't like it, the legal system says you can quit. Now, employers argue that this arrangement is reasonable. They say they have a legitimate business interest in monitoring work activity. They need to protect company data from theft or breach. They need to ensure people are actually working and not just pretending. They need to prevent misconduct and fraud. These aren't frivolous arguments. Companies do face real security risks. Data breaches cost millions of dollars. Employee theft is a real problem. These threats are not imaginary. But here's where the conflict becomes real. Monitoring technology has evolved far beyond what's necessary to address those business interests. Keystroke logging software that records literally every key you press. Screenshot systems that fire every 5 to 10 minutes, 24/7. GPS tracking on work phones that follows employees even when they're off the clock. Amazon warehouse workers wearing wristband sensors that track their exact location and movement, and which can notify them automatically that they're not working fast enough. AI systems that analyze employee activity patterns and automatically fire workers who fall below productivity thresholds. One company even tried to monitor whether employees were smiling in video calls. Workers argue that this has gone way beyond what's necessary. They argue it's invasive. It's degrading. It creates an atmosphere of suspicion and paranoia. It affects behavior in ways that seem unreasonable. If you know your web browsing is being logged, you might hesitate to research mental health. You might skip calling your doctor. You might not look up your legal rights. You might not visit support group websites. All because you know someone is watching. There's also evidence that invasive monitoring does not actually improve productivity. Some researchers have found that employees under heavy surveillance report higher anxiety, lower morale, and lower job satisfaction. Turnover increases. People quit jobs specifically because of surveillance. The companies that use the most aggressive monitoring often have higher turnover rates. So the surveillance might be counterproductive. Yet the industry has exploded, especially once remote work became normal. By 2020, demand for monitoring software had skyrocketed. Companies that had never tracked employees before suddenly were. The pandemic gave employers the justification they needed. So here's the central question that sits at the heart of this issue. Just because something is legal, does that make it right? And more importantly, should the law even allow it? This is not a new question in American history. In the mid-20th century, the workplace faced similar power imbalances. Factory owners monitored workers intensely, foremen watching every move. Workers had almost no privacy, no control over conditions, no say in how they were treated. Workers saw this as degrading. They fought back. The labor movement demanded change. And over time, American law responded. We created labor laws that protected workers. Overtime rules, safety standards, minimum wage, the right to organize. These laws said, employers can't just do whatever they want. Employers have power, yes, but that power has limits. But here's what's interesting. Other countries took that principle much further. Germany, France, most of Europe. These countries have much stronger employee privacy protections. The European Union has GDPR. Many European countries require employers to prove that surveillance is necessary. They require it to be proportional. They ask, is this surveillance actually needed to protect a legitimate business interest? Could you achieve the same goal with less invasive methods? Those are sensible questions, but they're not being asked in America. Instead, we've gone the opposite direction. We've made it progressively easier for employers to surveil employees. We've prioritized business interests over worker privacy. And the assumption in American law is that if it's not prohibited, it's permitted. The burden is on the employee to prove it's wrong. But it's almost impossible to prove because courts keep ruling in favor of employers. That is starting to change. Some states are pushing back. California has passed stronger privacy laws. New York is considering legislation specifically about employee monitoring. A few workers have filed lawsuits arguing that excessive monitoring violates their emotional well-being, causes anxiety, damages their dignity. These cases are just now beginning to work their way through the courts. What happens next is genuinely uncertain. Employers are not going to voluntarily stop monitoring. It works for them. It's cheap. It's effective. But pressure is building. Younger workers increasingly care about privacy and are refusing jobs at heavily monitored companies. Courts are asking harder questions. Legislatures are considering bills. Some major tech companies, like Microsoft, have already dialed back the most invasive surveillance features, partly because of public backlash. The question for workers right now is simple. If you find yourself in Marcus's situation, if you discover your employer is monitoring you more invasively than you expected or feel is reasonable, the important thing to do is talk to a licensed employment attorney about what your specific rights and options are under the employment laws in your state. Laws are changing. You may have more protection than you think. Knowledge is your first line of defense. This is educational content, not legal advice.